recording in place. There we go. Well, welcome everybody to Privacy Law Changes and What You Need to Know Now. Today's the 12th of February and this recording will be available for people in the future. Now the timing of this recording is really important because Australian privacy laws are going to change on the 12th of March. So we've got 1 month and it's the shortest month of the year before we need to be really organised in terms of what we're doing in business. Now we've got a couple of, I should introduce myself, sorry about that. For those of you who don't know me, my name is Jeanette Jifkins. I am a qualified lawyer. I have the right to practice in Queensland and Victoria and in the High Court of Australia. I've been in practice for around 15 years. Previously, or in my early career, I was in law firms and worked in different areas such as litigation and dispute resolution, and then moved into corporate advisory work. Then about halfway through my career I moved into in-house, which means I started working inside companies and advising the company about what legal issues it faces instead of dealing with a bunch of clients in a law firm. And then about 4 years ago I got involved with Andrew and Daryl Grant with Our Internet Secrets and found them to be fantastic mentors. They encouraged me to go into looking at the legal issues of doing business online and helping people, particularly in that area. So that's a little background of where I come from, and this is the first webinar that I've done by myself. I've been interviewed on plenty of webinars, but this is the first one I've hosted myself. So thank you to Mark Robinson for helping with the setup of the webinar. Alrighty, privacy. Now there's the fine print you need to know as part of this webinar. This webinar is being recorded. There will be questions at the end. You are consenting to being recorded if you participate in questions, and unfortunately I can't do anything about that because of the way this is set up. I'm not going to edit the webinar afterwards and take out people's voices. So if you participate and speak on the webinar, it will form part of the recording, and that's not revocable. You don't get paid for participating in the webinar. It's a free participation. The recording will be publicly available, and copyright in the recording belongs to Law4 websites. There's your fine print. Now, getting into the meat of privacy. Is your business affected? If you're a private entity, so you're a company, a trust, a sole trader, any of those sorts of things, a partnership, as a small business, now a small business is $3 million turnover per annum or less, now you're covered. Previously, small businesses were exempt from privacy law obligations, but come 12th of March, that will all change. Government and semi-government entities have all been covered since 1988 when the Privacy Act was first introduced. It's expanding. So as I say, small business is affected. If you are a health service provider, you have been liable to protect private information consistently since the beginning of the Privacy Act. Well, not quite the beginning of the Privacy Act, but for a fairly long time. So if you've got any sort of health information, then yes, you should know about your privacy obligations. If you're in the business of collecting personal information, and I actually had a chat with somebody on the weekend who has the business of running a directory. So they go out there and they source information and they put it into a directory and they make it publicly available. That is actually covered by privacy law now. And credit reporting agencies and credit providers have always been covered by privacy law and had privacy obligations. For credit reporting agencies, the ability to report more information and to record more information is what will happen with the change in the Privacy Act come 12th of March. So getting down to brass tacks, what is personal information? Personal information, for one, it's information. It can be opinion, and it doesn't have to be true. It just has to be recorded in some form that can be distributed or accessed. It needs to be about an individual as opposed to a business. Now, the person I was talking to you about before, who has a directory, her directory is aimed at businesses, but some individuals are named in the course of that directory because they may be sole traders. Because an individual can be identified through that information, then it is covered. So yes, it's about an individual as opposed to a company, and the identity has to be what personal information does is it makes a person's identity apparent from that information or reasonably ascertained from that information. So if you can see a couple of pieces of information and together they help you identify an individual, then that is still personal information. Okay. Now, there are different ways to collect, use and hold personal information, and these are technical terms in the legislation. So they're not exactly what you might think they are. Now, holding information can just be inadvertently collecting it. So I don't know about you, but I have a huge inbox. And anybody who is storing emails that come in, and they might answer them and then the responses sit there. Sorry, I just had a question. What do you mean by covered? And what I do mean by covered is that it does come within the scope of legislation and you are bound by the legislation and may face penalties if you don't comply. So your business, as a small business, if you are collecting personal information, you now have obligations under the Privacy Act. And collecting personal information can be as simple, or holding personal information can be as simple as an increasingly sized inbox. So when you get an email, if you don't have any process for dealing with that, you're holding personal information. Ordinary mail, stuff that you might file in a filing cabinet, if it's got personal information on it, which can be as simple as a name and an email address, or a name and a phone number, name and address, any of those sorts of things, that's personal information. You can also access it from other sources. So I have worked with a business where we had to put a statement on a directory that that business published of its members. Now, it published that directory for the purpose of people being able to source services from those members. The trouble was promoters were coming in and saying, hey, this is exactly my target group. I want to market stuff to this group. And they would scrape the email addresses off that website and then go and promote information to those people. The people who were on the list, for the purpose of providing services, got pretty upset when they kept getting all this marketing information. So to get around that, we had to put a statement on the website to say this information is for this purpose only and is not for marketing, and the people who've put their names on this list do not consent to receive commercial information. So that's how we got around that. Now that's actually a spam issue as opposed to a privacy issue, but you can see how they're all interrelated. Generally available publications is a way of collecting information and making it available. So you might, for example, there's a hole-in-one publication. So everybody in Australia who gets a hole-in-one on a golf course, that gets recorded. When it's recorded by the club can now send it to a publisher, and the publisher will put it in a book, and then everybody whose name is in the book can say, hey, look, I can prove that I got a hole-in-one because my club's endorsed the fact that I did it and I'm now published in this book. That is a generally available publication. It doesn't have to be paid for. It can be free. And that's a way of collecting personal information and making it available. Now, using personal information, somebody's thrown me a question about clients. The information that you collect about clients is personal information. It is covered by the Privacy Act. And this is why I'm saying as a small business you now have concerns, because every client file that you have that you didn't worry too much about before, you now need to think about how you're dealing with that information and how accessible it is to other people within your office and what you do with it. So I've got a quick poll for you, and I'm hoping this works. You should have up on your screen a quick poll, and if you want to tick one of those boxes and submit, then we'll see how many of you are aware as to whether or not you're collecting personal information. Okay, give it a minute or two. We've got, oh, this is fantastic. It tells you how many people have voted. 62%. 30 seconds. We'll give it 5 more seconds. Okay, that's 86% of the people attending voted, and every single one of you have said that you collect personal information. So I'm glad to see that this information is relevant to you. Alrighty, if you have sensitive information, you've got extra obligations and you have to be more careful around the way you keep it. Sensitive information, just so that you're aware or have a level of awareness around what it is. Health information, information collected for the purpose of immigration. It can be race, ethnicity, political opinion, trade union membership, sexual preferences, criminal records, all sorts of different things. That's sensitive information, and if you look into the anti-discrimination legislation, it's pretty much everything that's covered in anti-discrimination is considered sensitive information. But then on top of that, you've got the health and the immigration and things like that. Just be aware that if you're collecting any of that information, that you've got extra obligations. We won't go into detail into what that is because most people don't collect sensitive information. Okay, the Australian privacy principles. Now this is the big change. What's happened in the Privacy Act previously is you had information privacy principles and you had national privacy principles. And the national privacy principles applied to organisations and the information privacy principles applied to government and semi-government organisations. They were similar but they had differences. What they've done now is brought it all together and said, okay, the Australian privacy principles will replace both of those, and we will end up with one set of privacy principles that apply to everybody across the board. Those privacy principles, there's 13 of them, and I'll just go through the headings with you and give you a really quick snapshot of what that's about. The first thing is, and this is new, this wasn't in the previous version of the privacy principles, you've got to have open and transparent management of personal information. Now it was implied before, but now they've spelt it out and said you have, this is the key philosophy around what you're doing with personal information. So open and transparent management of personal information. This is why you have a privacy policy, because you tell people what you're doing with the information you collect from them. Sorry, I'm just going to take down the poll. Can you let me know if it's gone? And if it's not, then it's gone. Okay, fabulous. Alrighty. Back to Australian privacy principles. Now I'll just flick back to the other screen in case you missed that. The extra obligations, that was sensitive information. So if you want to have a, thank you everybody for letting me know it's gone. If you want to come back to the webinar later and run through the sensitive information, there's a list of them for you. Okay, Australian privacy principles. The second one is anonymity and pseudonymity. Now the whole purpose for this was to say that people should be able to access information without having to be identified. And this is going to be interesting with all those marketing websites that say you can't get this information until such time as you log in. And I don't know about you, but they really bug me. I hate searching and then finding a website that's supposed to provide me with the answer I want, and it wants me to log in before I can access it. You know, it might be just the price of something I want to buy, but I can't even see the price of something I want to buy unless I log in. Well, potentially that could become a breach of the privacy principles, because you're requiring people to identify themselves before they can get access. And the privacy principles say you've got to give people the opportunity to be anonymous unless it's essential to your service provision that they're not. Now, there are bodies out there. So, for example, I work with an accreditation body, and from time to time they accredit university courses, and from time to time they receive complaints from students. Now, there's nothing they can do with those complaints unless they know who the student is and where they've come from and what course they've done. Otherwise the information's meaningless, and they can't go back to the university and say, hey, there's an issue. So in that particular case, they don't have to provide anonymity. They can require a person to identify themselves. But if you're just giving information on the internet and it's otherwise freely available on other websites, then requiring somebody to give you their identity first is potentially a breach. Okay, collection of solicited personal information. Now, what this means is putting a name capture on your website. Now, there's the anonymity issue is only if you make people give you their name and email address. Collection of solicited personal information, generally if you've got a web form on your website that says, here, give me your name and email address, what you're doing is saying to people, you have a choice. You can do it, and as a bonus we'll give you a report. But the balance of your website they can access without having to give you their contact details. It's just a special thing. In order for you to deliver that particular report or book or whatever it is that you're giving to them, they need to give you your details so that you can actually send it to them individually. Now, you may be able to provide that free on your website, but the purpose of providing the report is to attract or identify people who are really interested in the products or services that you have to offer. So there's a leeway in collecting information that way, and it's mainly because people have a choice. Unsolicited personal information is where you might go and buy a list. And what I mean by this is, for example, if there's a big workshop or convention with lots of stands and people pay to get in, like the home and garden conventions and the boat show and all those sorts of things, what tends to happen is a list is created either of the attendees and or a list of the exhibitors. Those lists can be made available for purchase. And it doesn't mean you're necessarily told that they are, but I'm aware of a business that used to buy lists from bridal expos in order to market to all the people who attended bridal expos, because that person had a product that, you know, was very popular with newlyweds or for newlyweds as wedding gifts. If you're going to go and do that, that's unsolicited personal information, and you're going to have you've got to take extra care around using that information. Now, the advice I gave people on the weekend was, yes, you can send something to these people. Don't market to them. Send them an invitation to receive marketing from you. So you say, hey, this is who we are, this is what we do, we have a newsletter, you can subscribe this way. And if they choose not to, then you don't market to them again. So you can't buy a list and then add them straight in and then just start marketing to them without their permission. If it's unsolicited personal information, you have to get their permission first. Okay, next set of privacy principles. Notification of the collection of personal information. Now, this one I find particularly troubling because I seriously don't think it's workable from a practical perspective. Now, regardless of that, what it says in the legislation is that if you collect personal information, particularly if it's unsolicited, then as soon as possible after collecting that personal information, you're supposed to contact the person it relates to. Tell them you've got their information. Tell them why you've got their information. Tell them what you're going to do.